Without further ado, super excited to introduce Jeff Rabin. Jeff is an attorney at the law offices of Rabin and Associates. He's been licensed in Illinois since 1980. He's focused his law practice in the representation of disabled individuals seeking benefits under the Social Security Act. Jeff founded Jeffrey A. Rabin and his Associates in 1988, and he has represented clients nationwide at all levels of the administrative process and in the federal courts. The frequent speaker on Social Security issues, Mr. Rabin has lectured nationwide to a variety of community, legal, insurance, and government agencies. He has lectured a number of times at the National Organization of Social Security Claimants Representatives, and he's testified before Congress on Social Security issues and was featured in a 60-minute story in this area of the law. So without further ado, Jeff is going to be speaking on Social Security disability, change, and confusion. Thanks, Jeff.
Thanks, Patrick. And just can you confirm for me that I did the screen share correctly and that you're seeing my PowerPoint?
Yep, everything's perfect.
Okay, now I'm just going to try to figure out though how to change the slides because I'm working on multiple screens and I've just made my life a lot more challenging. So just bear with me one moment. And okay, that should work. I'm having a problem while there.
Jeff, I can share for my screen if you prefer.
Okay, yeah, and I don't know why this worked for me when I practiced it and I didn't have a problem.
Try your up and down arrow.
No, I am. Ah, got it. Never mind. We're done. I can do this. Thank you. All right. So Patrick, thank you for the introduction. Gail, thank you for the help. My name is Jeff Rabin and I'm an attorney, and all I do in my law practice is help people who are disabled and are trying to get benefits from the Social Security Administration. I began working in a small general practice firm in Chicago in 1980, where I got stuck with the Social Security work. That was because nobody else wanted to deal with this clientele or this bureaucracy. As time went on, I found I liked the clientele and I liked the bureaucracy a whole lot more than I like other lawyers. So the nice thing about my work is I don't have to deal with other lawyers. It's me, the client, the judge, and off we go. I did my first disability case in 1981, set up my own law firm in 1988, and have moved forward since then. As Patrick said, we've covered this, we've spoken about this area of law all over the country. I'm a past chair of the Chicago Bar Association, Social Security Committee, and the present chair of the National Alliance on Mental Illness, NAMI DuPage. So we're going to have some fun covering the basics of the law today. Now, our normal presentation goes about anywhere from 60 to 90 minutes, and we don't have that much time today. So we're going to kind of skip through some of the slides in the PowerPoint, but I will give my information at the end, and the last slide will have my contact information. And if you want a copy of the whole PowerPoint, just shoot me an email and I'll be happy to send that out to you. I'm also really looking forward to questions, so please make sure you enter them in the chat box and we'll cover those at the end. We're going to talk briefly about what the law says and what it means to be totally disabled. We're going to talk about what SSDI is and what SSI is and what the differences are, because those differences are really key to your understanding how to plan moving forward. We're going to talk a little bit about the analysis and how Social Security thinks about cases, and we're going to talk about the keys that are so critical to getting a claim approved, and that's really the focus of this whole talk. We're going to touch briefly on what happens after the claim is approved, because that's really an important part of the program. And then we'll have time for questions. So let's first start talking about what's happening since COVID-19. So first, Social Security is still operating. It's chugging along. It's not zooming along, but it's chugging along. All the offices are closed. People are working from their homes. Checks are still being processed. We're having administrative law judge hearings, but not face-to-face. They won't even do video hearings because under their guidelines, their video hearings can't be done on Zoom or go to meeting. They have to be done on a very specific, high-tech, high-secure system, and they require at least 2 people in the office, and the judges won't share an office with a hearing monitor. So all of our hearings now are being done by telephone, which has some very inherent disadvantages when a judge can't see or visualize that person that's testifying. So all of us that are advocating in this field are being somewhat selective on the cases that we're allowing to go ahead by telephone, and the rest are just being put in a queue for when the offices do eventually open. We can go back to face-to-face hearings. No idea when that's going to be. I have gotten a lot of calls from people saying, I'm a high-risk person and can't go back to work because of COVID-19. Can I get disability? And the answer is no, because Social Security disability isn't paid on what may happen. It's only paid on what is happening. And that's our transition to our next slide, which is talking about what does it mean to being totally disabled? When someone calls me and they want to get disability benefits, either SSDI or SSI benefits, I've got to prove the existence of permanent physical and mental impairment, persistent so severe precludes the ability to perform a substantial gainful activity available in the national economy for a period that's less or expected to last 12 months or result in death. And I always say that really fast because that's the legal mumbo jumbo. Here's what it really means. In order for me to get somebody benefits, I have to be able to prove that they are suffering from symptoms which so impact their day-to-day life as to make it impossible for them to function at any type of full-time work activity available in the national economy. And I said that very carefully. I did not say that I have to prove my clients have medical problems. That's not the test. The focus in a disability case is on what are the symptoms from those medical problems and how do those symptoms impact this particular person's ability to function in a work setting. I get calls all day from people who say, Mr. Rabin, I have high blood pressure and sugar diabetes and I want to get SSI. And my response is almost always the same. It's so what? Take your medicine, watch your diet, get some exercise and go to work. That's not to minimize the severity of hypertension and diabetes. My father passed away from untreated hypertension. But that's not the focus. The focus is not on whether they're have a label. The focus is on whether that condition is producing symptoms that impact function so as to make any type of full-time work activity impossible. So when I get calls from people who have a physical medical problem, a bad heart, a breathing problem, a bad back, my questions are, what are the symptoms from that physical medical problem? And how do they impact your ability to do the physical motions involved in a job? Sitting in a chair, standing, walking, lifting, reaching, pushing, pulling, lifting, those physical motions that are involved in every single job. How are they impacted by the symptoms from that physical medical condition? If I get calls from somebody who has a mental impairment, major depressive disorder, anxiety disorder, agoraphobia, PTSD. The most common call we get is bipolar disorder. What are the symptoms of that mental disorder? And how do those symptoms impact the ability to do the basic mental motions of a job? Understanding and remembering simple 1 or 2 step instructions, interacting appropriately with supervisors and coworkers, dealing with work changes. Those basic mental motions that are involved in every single job, how are they impacted by the symptoms from whatever label the psychiatrist happened to put on this person? You see, Social Security will rarely deny the diagnosis. If a guy has a scar 6 inches down the middle of his back, he had a back fusion. And Social Security is never going to deny that he had a back fusion. What they're going to say is, so what? He had a back fusion. What are his symptoms now? And what can he do on a sustained basis despite that back fusion? And they call this in their lingo, your residual functional capacity to perform work-related activities, RFC. What can you still do on a full-time basis despite your medical problems? And we're going to come back to that RFC phrase a couple of times this afternoon. But let's take an example. Let's take a 48-year-old Chicago union carpenter. He's climbing the scaffold tips, lands on the ground, and he fractures 2 vertebrae and herniates a disc in his lower back, and he needs a back fusion. Union carpenters in Chicago make about $43 an hour plus benefits. He is never going to be a $43 an hour union carpenter anymore because he's not going to be able to bend and saw all day and climb scaffolds and carry 2x4s on his shoulder. That's not the test. Social Security disability is a total disability program. So the focus in his case is whether I can prove that he cannot do a job like ticket taker at a movie theater, sit-stand option job, wear a little blue jacket, rip the tickets in half, door number 2, enjoy the show. Ticket taker at a movie theater, coin changer at a self-service gas station, shoebox packer in a shoe store, washing machine unloader in a laundromat. These are all the types of jobs or examples of jobs that Social Security has used to deny my clients benefits in the past. A number of years ago, I was representing a lady who had been a cardiac intensive care nurse in a downtown Chicago hospital, zapping people like we see on TV and saving lives. And she developed rheumatoid arthritis, and this was before the biologics were out, and she ended up with 2 deformed claw hands. Social Security denied her application, saying that she had the RFC, residual functional capacity, to still function as a bicycle rental clerk. Back when you can help substance abusers, and Patrick had mentioned I testified before Congress, and that was on the issue of whether substance abusers should be able to get benefits. They can't anymore, and we can answer questions on that if you have them. But I was representing a substance abuser who was living in the Gateway Kedzie House program, and back in those days, that was a 1-year residential program, really effective, good program. They denied his application, saying that he retained the RFC, residual functional capacity, to function as a bank vault security guard. Now, when I told Henry the heroin addict they wanted him to guard the bank vault, he said, "Mr. Rabin, I wish how I wish." The point of those stories is my lady was never going to go rent bikes, and Henry was never going to get a job as a bank vault security guard, but that's not the test. The test is not whether they could get those jobs. The test is whether I could prove that they could not do those jobs. If I could, I won. If I could not, I lost. If you're taking notes by any chance and you want to write down one word that summarizes everything that we've talked about so far, that word is the word do, D-O. Social Security disability claims are not about whether you have a medical problem. Social Security disability claims are about the symptoms and what you can still do on a sustained 8-hour-a-day, 5-day-a-week basis despite those medical problems. Now, that basic law, proving the inability to function at any type of job for a period that's lasted or expected to last 12 months or result in death in 12 months, applies to 2 basic programs. And we're going to just hit the highlights of these programs. There are subsets beneath them, and we can talk about those if you have questions. But the first program is called Title II of the Social Security Act, or Social Security Disability Insurance, or SSDI, or Workers' Disability, or Regular Disability. We'll call it SSDI this afternoon. The second program is Title 16 of the Social Security Act, or Supplemental Security Income, or SSI. We're going to call that SSI. So we have SSDI, SSI, those are our 2 main programs. We're going to first talk about SSDI because it's the more comprehensive program. It has 2 requirements. First, we have to prove total disability. That's the medical test that we just reviewed. Second, we must prove that our client purchased the insurance, Social Security Disability Insurance. This is an insurance plan. It is no different than your car insurance and your homeowner's insurance and your health insurance. And I know some of you are thinking, I know I pay my car insurance to State Farm. I know health insurance is paid through my work. I don't recall ever writing a check out for SSDI, but every one of you has. Because every one of you that has had a job made a deal with the boss. And if it's like my staff, they say the deal they made was for not enough money, they work too many hours under too much stress. That's just the nature of any boss-employee relationship. It's all really good in my office. But the problem is, whatever deal you made with your boss, they've never kept the deal, because not one of you has ever gotten a paycheck for what the boss promised. Why? Because every paycheck you've gotten has had a stub attached to it. Now, the top line on that stub says federal withholding. That's the money that goes off to Washington, D.C., and it pays for the Army and the Navy and the Air Force and the Smithsonian Institute and all the different good, bad, and crazy things that the federal government does. The bottom line on your check stub says state withholding. And here in Illinois, that money goes down to Springfield, and other states it goes to wherever the capital is there. And the governors and the state legislatures get to play with it. And we know that in every state, some of that goes for roads and bridges, some of that goes for public education, and not enough of it goes for Medicaid, which is always an issue. And then you've got the lines in the middle for the money that goes over the rainbow to the land of FICAville. Now, those of you that may have a little gray like I do, remember when our checks actually said FICA? They don't anymore. It's now divided up into two lines. One says OASDI, Old Age Survivors and Disability Insurance, and the other line says Medicare. And combined, those are your FICA payments. Now, the boss matches that. Every dollar taken out of your paycheck for FICA, the boss reaches into her purse and she matches it dollar for dollar. And that money goes off to Washington, D.C., and it goes, well, actually Virginia, and it goes into the Social Security trust funds. And that's an important concept to understand. None of us have money at Social Security. None of us have accounts that are growing. None of us are getting interest or getting any benefit from stock market increases or suffering from stock market decreases. That's not what this insurance is all about. Instead, the money goes into three trust funds. The big one that eats up almost all the money is called Social Security Retirement. Then there's a little one off to the side. Now, little is in the billions, so this is all relative. And that's called Social Security Disability. There's a little one off to the other side, and that's called Medicare. And that's how these programs are funded. We work, our money is taken out of our paychecks, it goes up to the trust funds, and then is immediately paid out. So those of you who have parents or grandparents or aunts and uncles getting Social Security retirement benefits, or have friends or family getting SSDI or survivor's benefits in the event of the death of a loved one, those people are getting the money that we sent in from our last paycheck. And then whatever is left over at the end of the month that isn't paid out to current beneficiaries is loaned to the US Treasury at a ridiculously low rate so that they can lie to us about the size of the federal debt. Because if they actually factored the federal debt and the debt to the Social Security trust funds, nobody would have any faith in the US economy anymore. So that's how these programs work. People work, they pay their FICA taxes up into the trust funds, immediately out to current beneficiaries, balance loan to the Treasury. To qualify for SSDI, you have to meet a two-part FICA test. First, you had to have worked and paid FICA taxes for 40 quarters in your lifetime, or 10 years. Second, you must have worked and paid FICA taxes for 20 of the 40 quarters preceding the onset of disability. An easier way to talk about that is 5 of the 10 years prior to the date you become totally disabled. Let's take another example. When I give these talks, you learn a lot about me. I'm kind of an open book kind of guy. One of the things about me is I am one of the world's biggest klutzes. So after we get done here today, I walk outside my door. I'm wearing shoes with ties on them, and I trip on the sidewalk and I fall and bang my head. My wife gets nervous. She rushes me over to the local hospital. They do an MRI and they say, oh my gosh, Jeff's more brain damaged than he was when he started the AlderWorks presentation. And now I'm totally disabled. Living in Northern Illinois, I would go to the Waukegan district office and say, I had to get dressed for Jennifer Prell's presentation, and then I fell and cracked my head, and now I'm totally disabled and I want to get disability benefits. They would first pull my earnings record and see if I've worked and paid FICA taxes for 40 quarters in my lifetime. The truth is I've worked and paid FICA taxes for more than 40 years, so I'm covered there. Then they would say, pull Jeff's earnings records from 2009 to 2019, the 10 years prior to the year I became totally disabled. Did I pay FICA taxes for at least 20 quarters during that time period? If I only paid in for 18 quarters or for 3 years, or I worked for cash and never paid the man a dime, I'll have screwed myself because I would not have purchased the insurance. So worked and paid FICA taxes for 40 quarters lifetime and for 5 of the last 10 years, and I'm totally disabled. Under the SSDI program, when I'm approved, I will be eligible for a monthly check. The amount of that check is a computer formula based upon my age, how many years I paid into the system, and how much I paid into the system. They look at your last 35 years of earnings. And the average person on disability is getting about $1,250 a month to live on. And nobody gets rich or comfortable living on SSDI. In addition, dependent beneficiaries, that is kids under 16 or under 18 or under and still in high school, would get checks until they graduate high school. I get a cost of living increase every year. That is usually minimal, but it's helpful, whatever it is. There's still a lot of talk of changing how that COLA is calculated so that it won't be as significant for seniors and those on disability. And I become eligible for Medicare, the federal red, white, and blue health insurance, 29 months after the date I became totally disabled. Now that said, lots of different ways on the street. Let's define that. So this is August 2020 when I fall and bang my head. I'm totally disabled. There's no issue. SSDI has a 5-month, what they call elimination period. We call it a starvation period. So I would not get a check for September, October, November, December, January. My first SSDI check will be February of 2021. Medicare will kick in February 2023. 2 years, 5 months from the date I became totally disabled. 2 exceptions to that rule: people on kidney dialysis and people with Lou Gehrig's disease, ALS. And those are the only 2 exceptions to the 29-month waiting period. So that's the highlights of SSDI. Let's talk about SSI, because SSI is slightly different. Supplemental Security Income came about in 1971 after a series of pictorial articles in Look and Life magazines depicting the difference in living conditions between the elderly poor in the North, who are getting some help from their cities and townships and counties, and the elderly poor in the South who weren't and were depicted living in shanties and lean-tos and literally using cat food saucers for plates. Congress decided using cat food tins as plates and bowls was not a good way for people to live. So they enacted SSI for the elderly poor and then expanded it to help the disabled poor. So SSI also has 2 requirements. First, you must be totally disabled. It's the exact same medical test we talked about at the beginning of our discussion. Second, you must be indigent. Indigent for SSI purposes means no money coming into the household except from possibly TANF or child support benefits, and less than $2,000 in non-excludable resources. Non-excludable resources, what do we mean by that? You're allowed to own a home if you're living in it. You don't have to be homeless. You're allowed to own a car because you have to get to the doctors and the pharmacies and the hospitals. They won't value the clothes on your back, but they will look inside your wallet. They will look inside your purse. And I don't mean literally, but figuratively. They will look for checking accounts, savings accounts, IRAs, 401ks, 203Bs, cash value life insurance, US savings bond, family investment properties, poorly drafted family trusts, any asset that can be converted to cash, even if you have to pay a tax or a penalty to access it, counts against the $2,000 asset limitation. So SSI is a program for people who are permanently and totally disabled with very, very limited financial resources. If you meet those qualifications and you're living independently, you'll be eligible for $783 a month. Realize this program, which certain factions of Congress really despise and want to limit or eliminate, still leaves a totally disabled person 25% below the poverty level in the United States. Nobody gets rich, nobody lives comfortably, nobody is satisfied just living on SSI. It just isn't enough money. Now, there's a big gap in the SSI program. That gap is a concept called deeming. Deeming says what belongs to me belongs to my wife, what belongs to Sherry belongs to me, and what belongs to the two of us belongs to our minor children if we still had any. Deeming comes in to, I have a whole story, but because of time, I'm avoiding the story because it takes too long. Deeming comes in to really impact stay-at-home parents. I have probably averaged one call, email, online chat. People reach out to us in many, many ways, but probably averaged one contact a week, every week for almost 40 years. Now, I'm one guy sitting in an office in Northern Illinois getting contacted at least once a week on this issue. So if you expand that out over the whole country, you can imagine how bad the problem is. But the problem is for people, and it's men and women, but we're going to just use women as the example because that's the more common, who work, go to school, work, stay home, raise the kids. The kids get to be college age or older. The woman's in her late 40s, early 50s, and she's diagnosed with multiple sclerosis or breast cancer, or she's hit by a car or falls down the stairs. She can't get SSDI because she hasn't worked and paid FICA taxes for 5 out of the last years. Under deeming, her spouse's income is considered hers, so she's not indigent for SSI purposes. She can't get any benefits. Then what happens, and I'm not making these stories up, I get this call all the time, the spouse divorces her because she's sick and not fun anymore, but she gets a settlement in the divorce for her old age, gets part of his 401k or pension plan, still isn't considered indigent unless she cracks that, spends it, pays the income taxes and the penalties on it, blows it down below $2,000, and then she's indigent, and the government will give her $783 a month to live on. The rule in the United States is no matter how much our government talks about the importance of family values, we put no value on the stay-at-home parent. The stay-at-home parents who become totally disabled often end up screwed in our society. And it's just an unfortunate reality. So 2 programs, SSDI, worked and paid FICA taxes and totally disabled, SSI, totally disabled and indigent. Next, let's talk about how Social Security thinks about cases. And normally there's a long explanation here, but we're just going to hit some highlights. And what we've talked about so far is what's called the black letter law, the main law. But that law is redefined and refocused in the regulations, which are the fine print. The regulations are redefined by something called Social Security rulings. The rulings are amplified by the HALEX and the POMS, and all of that is reinterpreted by the federal courts. So what most people think is a very simple, clear-cut concept is actually pages and pages and volumes of legal inertia or legal data or legal minutia is the word I was trying to come up with. But in the regulations is an analytical framework called the sequential evaluation procedure. Now, I'm not your typical lawyer. I'm a roofer's kid. My dad was a roofer. My grandpa was a roofer. And the only reason I'm not a roofer is I was so bad at it. They threw me out of the family business. But I can only say sequential evaluation procedure twice in a day and my tongue goes on strike. So I talk about climbing a ladder because that's how I grew up, with the ladders rattling in the back of my dad's Pontiac and the smell of hot tar, which is still the greatest smell in the whole world to me. If you look at the ladder, there's a couple of points that I want to emphasize. First is the idea of a compassionate allowance. About 10 or 12 years ago, roughly, Commissioner Astrew at that time realized that there were some conditions that Social Security paid all the time. And if they paid them all the time, he asked, why are we making people go through all these hoops? Let's just award those benefits. So they did a study and came up with 50 conditions. It's now a little over 200. Now, most of them are conditions you've never heard of. They're very rare diseases. A lot of them have names 22 letters long, but some of them are kind of obvious. Brain cancer, lung cancer, Alzheimer's, pancreatic cancer. These are considered to be compassionate allowances. If you have a compassionate allowance condition, you do not want to go through the normal apply, deny, and appeal process. You want to let Social Security know right at the very beginning, big letters or scream on the telephone, I have a compassionate allowance condition. In that case, it's supposed to be expedited and reviewed and approved in a much quicker fashion. The compassionate allowance conditions are identified online. You can Google it, or you just call our office and explain your situation. And if you have a compassionate allowance condition, we can walk you through it without even having to represent you if you don't want us to. Assuming you don't have a compassionate allowance condition, you then follow the next 5 steps. And I want to highlight step number 3, meet or equal the listings, and then the last step. The listings are very specific medical requirements contained in the regulations. And there's lots of listings. There's listings for musculoskeletal problems. There's listings for cardiac and digestive and mental and systemic problems like lupus and scleroderma. Very high threshold. Cut my arm off, I don't meet the listing. Cut my arm and leg off, I'm a double amputee, you do meet the listings. But it's the first place we think about every time a new client calls, because it's also the first step where a claim can be approved. So judges always go through the analysis of whether somebody meets or equals the listings of impairments. If you don't, the only other way to get your application approved is at step 5, showing that based on your age, your education, your work skills, and most important of all, the thing that really matters, what they determine your residual functional capacity to be, whether there are other jobs that you could perform on a full-time basis. And that's the point in the analysis where we fight over the ticket taker and telephone operator and packer in a shoe store type jobs. If we can prove that your functional capacity is so limited you can't perform those kind of jobs, we win. If not, we lose. But this analysis, this ladder, is used in every single case by every single decision maker, adjudicator, administrative law judge, appeals counsel, federal court. Everybody uses exactly this analysis when they look at a new application. This is the most important slide in the proceeding. We've talked about that these cases are challenging, and they are. The standard is high. The rules have been changed significantly over the last 5 to 10 years to make it much harder to have cases approved, and the number of approvals nationally is dropping very steadily each year. But we can win cases, and it's important that we win cases. And to be perfectly frank, it's important for 2 reasons. First, and I'll only speak now about my office, but this is true for most reputable Social Security practices, we're very careful about the cases we take. In fact, in my office, we only take about 30% of the cases that when people call us. 70% we give other advice to. So when we take a case, we truly believe that person is entitled to these benefits, and we're going to do everything we can at every level of the process to try to get that claim approved, because we feel it has important merit. The second reason cases have to be won, it's the only way advocates get paid. Nobody can get a retainer and handle a Social Security case. Nobody gets paid by the hour. The only way we get paid is by winning, and then that fee is statutorily set. So it's really important that we win. 3 main rules for getting a claim approved. First, you must be going to the doctor. You must be going to the doctor. You must be going to the doctor. I can't say it enough. A Social Security disability claim is a medical claim. When we meet with new clients, we tell them at that meeting, what you say is never evidence that's going to win the case because you want the money. As far as Social Security is concerned, you would testify under oath that I still had a full head of curly brown hair if that would get you $1,000 a month. What your spouse says, your son says, your neighbor says, your priest says, that's not evidence that can get a claim approved because they like you. The only evidence that Social Security is going to consider when determining whether an application can be approved are the clinical charts of the treating medical specialist. It's what the doctor writes down while you're in the office. That is the evidence. This is an analogy that I dislike because I honestly never shot a gun in my life except for a BB gun back when I was a kid. But people like to think of their lawyers as their gunslingers going out to battle for them. I wouldn't know how to shoot a gun. Well, I could probably figure out a rifle because I like John Wayne movies, and so I watched him do that, but really shooting is not my thing. I shoot Beck depression inventories. I shoot MRIs. I shoot EMGs. I shoot neuropsychological evaluations. I shoot cardiac stress tests. If I don't have medical evidence, I do not have any bullets, I cannot win the claim. And put yourself in the position of an administrative law judge. You're only going to pay 2 or 3 of the 6 cases you hear every day. And every day, 4 or 5 of those people have pages and pages and volumes of medical records and charts. And 1 or 2 people come in every day and say, oh, Judge, I don't have good insurance and they're mean to me at the county and they don't help me and I don't go anyway, but send me a check. Who is the judge going to want to help? She's going to want to help the people that are trying to help themselves. So rule number 1, you must be going to the doctors. That is a deal breaker on any case. But rule number 2, there's a right way and a wrong way to go to the doctor. Now, here's what happens. You're raised well. Parents taught you to be respectful. Parents told you to open doors. Parents told you to say thank you. You're going in to see the doctor. You've been in the house for a couple of weeks, but today you're going to the doctor and you like the doctor and she's really nice and she's got a great smile. So today's the day that you shower and you put on a clean shirt, like I had to do for this talk today. And you trim what can be trimmed, you pat down what's left to be patted down, and you go into the doctor's office and the doctor says, "Hey, Jeff, how are you today?" And I don't want to moan and groan and complain. That's not my style. I was raised to be a working guy and take care of my responsibilities. I don't complain like that. So she says, "Hey, Jeff," and I say, "Hey, Doc, I'm okay. How are you?" Because I'm polite, and I just lost my disability case. Because what does she put in her chart? Well-groomed, nice man says he's okay. Next month I go in. Now the shirt's a little wrinkled and my eyes are red and I have this thing they call a flat affect, which means I look sad. And she says, "Jeff, any new symptoms? Maybe we need to talk about adjusting your depression medication." What do I hear? Adjust my medication. Now, I don't know how many of you have worked with or assisted people with mental health issues, but the last thing they want to hear is adjust my medication. I've been on Prozac, I've been on Wellbutrin, I like the Lexapro. I don't want to go up and down on these medicines and start all over. "Oh, no, Doc, there's no new symptoms. It's really just a bad week. The dog pooped on the carpeting, the kid got a D on his report card, but really there's no new symptoms." What does she chart? Jeff says no new symptoms. Next month I come in. Now I'm a mess. The clothes are all disheveled. I haven't shaved. I look terrible. I'm mumbling. And she says, "Jeff, are you sure things are stable? Maybe we need to talk about that day hospitalization program over at Evanston Hospital." What do I hear? Mental health hospital. I've been in a mental health hospital. Those are bad places. I don't want to go back to the hospital. "Oh, no, don't be silly, Doc. It's stable. It's just another bad week. I got called into the principal's office because my kid got in another fight at the school, and it wasn't my kid's fault. It was the principal's fault. You know, it's always the principal's fault. It's never my fault." And then the police were called, but really I'm stable. What does she put in her chart? Jeff says he's stable. Every note from every one of your medical providers is going to get reviewed. And what are they going to read in the psychiatrist's notes? Jeff says he's stable. Jeff says no new symptoms. Jeff says he's okay. Okay, case denied, go to work. And I'm going to lose. Now, I lied to my doctor. I lied for good reasons. I don't want to change my meds. I don't want to go to the hospital. I was just being polite and saying, "I'm okay, Doc, how are you?" But they're lies. And two things happen when you lie to your doctor. Number one, you might be seeing the world's greatest psychologist or psychiatrist, but she's not following you around with a camera and she can't read your mind. And if you don't tell her about your fatigue, about your concentration problems, about your anger problems, about going off on other people, about the fact that you're not caring for yourself appropriately, if you don't discuss these issues with her, she can't help you and you're not going to get good medical care. Second problem, if you don't discuss those issues with her, she doesn't write them down. And if they don't appear in the chart, they don't exist, and I can't argue them. So rule number 2, talk about your symptoms when you go to the doctor. We provide calendars with our clients to note their symptoms on a daily and weekly basis to help prompt their memory when they go to the doctor. We talk about talking about the person, or we remind people, talk about the person that they see in the mirror, because that mirror doesn't have an ego. And if you talk about that person's limitations and frustrations, you get a lot more information across to your doctor. Rule number 3, Social Security wants specialists. If your problem is fibromyalgia, you need to be seeing the rheumatologist or the pain specialist. Family doctors have very little role to play in most disability cases. If your problem is migraines, it's the headache specialist or the neurologist. If your problem is depression or anxiety, getting Prozac from the family doctor is not evidence. They want you to be seeing a psychiatrist and a therapist, or a really good PhD or PsyD psychologist. you must be seeing the specialists. Those are the 3 keys to developing the evidence in order to prove a disability claim. The last item here is persevere. Claims get denied, don't give up, keep treating, keep documenting your problems, and keep pushing ahead. I want to talk about that just for a moment. You see, these are the different steps in the disability process. The key one is the 3rd step, which is the hearing before the administrative law judge. Everything up to that level is done by phone and mail. You never get to see or talk to the ultimate decision maker. Everything after the ALJ level, the appeals council or U.S. District Court, you never get to see or talk to the decision maker. The only time a claimant with severe medical problems gets to discuss his issues with the decision maker is at the administrative law judge hearing. So that's the fulcrum. Most times now, we're actually hired before people even start their application. In fact, it got so much to that point that we've hired a person in our office whose only job is doing the applications for people, just to make it easier and to move these cases ahead. But everything we do is geared toward that administrative law judge hearing, because that's the most powerful way to get an application approved. All right, I want to switch gears for a moment because many of you work with people who are getting benefits. There's a lot of issues about going back to work. These rules are described in the handout if you want them, here and here. But what I want to talk about are continuing disability reviews. Everybody's going to get reviewed. That's not an issue. You are going to get reviewed. Here's what happens. I work with a client and I'm persistent, and so is my staff. Go to the doctor, go to the doctor, go to the doctor. You do go to the doctor. We win your case. I stop nudging you. You stop going. A year later, you get a call from an adjudicator or a letter. Hey, Mr. Rabin, you've been getting benefits for a while now. My job is to do a continuing disability review. When I do a continuing disability review, the test is there medical evidence of medical improvement sufficient to allow you to return to work? Now, I'm going to start with your doctor. So who are your doctors? And you answer, well, I haven't been to the doctor in a year. Jeff hasn't been nudging me. And a big smile comes to the adjudicator's face. He says, don't worry, honey, I'll send you to one of ours. And you're going to go to a Social Security consultative examiner. Now, I don't know if any of you have ever sat in on a consultative examination. I have. It's get on the table, get off the table, walk heel to toe. Tell me how many fingers I'm holding up and what's the difference between an apple and an orange. And you can't prove fatigue, and you can't prove pain, and you can't prove concentration problems to any significant extent. There's going to be a finding of medical improvement, and you're going to be terminated.
Jeff,
So
we have about 5 more minutes and we have a couple of questions.
that's absolutely perfect. I have exactly 4 more minutes to go.
Okay.
This will, I can finish in just a moment, Gail. I'm almost done. The key rule here, even if you're getting benefits, you must be going to the doctor. That is the key. If you want more information on how to return to work, that's contained in here. rkblegal.com is our law firm website, and there's a lot of information and articles and videos attached there to answer questions. I'm very proud of my associate Spilios Bakuyanis, who just became the chair of the Chicago Bar Association Social Security Committee for the next year. If you have not signed up for My Social Security on Social Security's website, please do that right away. That's important. Last, I want to thank Jennifer, Gail, and the whole ElderWorks team for putting this together today. This is a huge project. They've done a fantastic job. We do a monthly newsletter on Social Security issues. So if you're interested, if you're a professional or work with an agency and want to get that newsletter, just send me your snail mail address and we'll be happy to send it out. Here's my personal information. We'll leave that up. And Gail, you want to tell me the questions?
Yes. If you're currently collecting SSDI benefits, but you are soon to reach your normal retirement age under Social Security, is there any need or benefit to transfer from SSDI program to the Social Security program? For example, is the SSDI program funded differently from Social Security? Or is either one of them better funded? Could there be one cut off but not the other?
No, makes no difference. You go automatically at retirement age. They do it automatically. They move you from the disability trust fund to the retirement trust fund. There's nothing that you need to do, and it's sort of invisible at your end. The retirement trust fund is funded slightly better than the disability trust fund, but at some point Congress is just going to have to bite the bullet and figure out an answer, because it's just a problem, a national problem that has to be solved. More than 60 million people in the United States get Social Security benefits. At some point, our leaders have to do what they're supposed to do and come up with a resolution to the trust fund funding going into the future.
So I guess for clarification purposes, there's someone has asked, can you have both SSDI and SSI?
Same thing, you'll just move to the retirement trust fund at retirement age. If your retirement benefit is under the $783 amount, you'll still get some SSI to bring you close to that amount.
Who initiates a CDRS, and when does it typically occur if you are on SSDI?
So you never know when a continuing disability review is going to be done. It's initiated by Social Security, and you'll usually hear from BDDS, the Bureau of Disability Determination Services, through Social Security. Every claim that's approved is secretly coded by Social Security for when they suspect there may be medical improvement. So you never really know when you're going to be up for a CDR. The judge might say in her decision, I want this claim reviewed in 24 months. And somebody back at the main office of Social Security will sort of giggle, and they'll decide on their own when that CDR should occur. Sometimes they happen and you don't even know it. They just see the nature of the disease and then they pass on to the next case.
The last one here, questions about self-employment on application. I'm working on any advice there.
Yeah, self-employment is always an issue. First of all, hopefully you followed the law and were still paying your quarterly FICA taxes while you were working so that you paid into the system. Many people who are self-employed pay their income taxes, but do not pay their FICA taxes, and then get a really nasty surprise when they file an application and found that they don't have quarters of coverage for disability purposes. Otherwise, when it comes to any type of employment, when you're completing your application, you want to describe your work focusing on the most physically demanding and the most stressful parts of your job, so that when Social Security is analyzing that work, it's harder for them to say that you have an RFC that allows you to do that kind of work anymore.
Okay, that is it. Thank you so much, Jeff. That was such a great presentation. Everybody, I hope you will join us for the next presentation on